True freedom requires the rule of law and justice. But what is justice without respect for human rights? What are these rights? Do you know your right as a citizen of the Federal Republic of Nigeria? What are your obligations and responsibilities under the law? Join Kayode Aderemi Esquire on The Law and You on Rockcity 101.9 FM, Sundays 3 p.m. to 4 p.m.
Abeokuta, Ogun State, that's Nigeria, West Africa, and this is your darling station, Rockcity 101.9 FM. Alright, this is your program, like I usually say, and that's the truth. It's about you, it's not about me, alright? Okay, it's about me too, somehow. But your program titled The Law and You. It's so much your program that even the word you is there. I want to thank all our callers, all our donors. As a matter of fact, some people, a lot of people call after the program. Some even donated some money to do an NGO for this program. Yeah, maybe they're listening to me now. I've never met them before. Some came into my office, some dropped some check, some sent in some money. They said, let's have an NGO to pursue people's rights. I am actually amazed, and I'm still flabbergasted, short of words. I'm very, very thankful for all persons, especially since you have never met me before, you've never known me before, and then you are doing these things. They even go as far as contributing money for people who are cheated. They never met them before. Want to just hear that I talk about a thing on the program, someone that has been cheated, they call me after the program and say, how can we help? I really appreciate every one of you. May God bless you all richly. Amen. Now, if you missed last week's program or previous weeks, or even if you did not miss it, please go to your browser and type Rockcity TV. There you'll see video recordings, courtesy of AK. Hakeem. He's been doing quite good job. He uploads to our YouTube channel. Just type Rockcity TV. There you'll find TV broadcast of our shows live here on Rockcity 101.9 FM. Remember to watch it, please. Like it, subscribe, share, and after you have done all these things, remember I said watch it, like it, subscribe to it, and share it, or share them. There are many there. Then tell me when you do, please. After you are done, if you have my number, just do a WhatsApp message. Tell me you have done so. You can drop comments if you wish, or if you would do. I'd like to see all those. All right. Last week we had a very, as usual, very rewarding session here in the studio. We had a guest all the way from Lagos who came to do justice to the topic we had last week, and because of time's sake, we could not take many of our calls, and I'm very sorry about that. Today we shall, because of what happened last week, we shall donate so much of our time today to questions answering and questions and taking, and also get your feedbacks about labor generally and employment. We have lots of questions. We'll try and rush through them today. Let me just do a very quick introduction of our guest by way of reading his profile as quickly as possible. He's Ireoluwa Oguntunwase. He's a senior associate in Elvira Saleras and Associates. That's a commercial law firm, in case you are wondering what it is, in Victoria Island via Lagos State, Nigeria. He is the founder of Labor Clinic Niger, an Instagram platform which he created to advise people and enlighten them, that is employers as well as employees, on sensitive labor law issues. He is also a lecturer at the Chartered Institute of Personnel Management, CIPM for short. That's the Ikeja chapter. He was here last week to discuss many things. I remember summarizing them in Yoruba. But you can please, I want to join us to go to his Instagram page. You're free to ask questions there. Labor Clinic Niger altogether. That Niger is 9JA. Labor Clinic. Labor LABOUR. Clinic Niger 9JA. On his Instagram page. Then you're free to engage in there, ask questions. You can follow him up too, really. He has some questions that programs that he runs. You're free to participate in them. Alright, I got calls as well that some said they missed last week's program, and many people called them that it was quite rich and rewarding. Because of that, I would, our guest is here by the way already. I would like that our guest should do a very brief recap, a very, very brief one for those that were not able to catch in last week. But please, if you want the full version, just type Rockcity TV on your browser and check out all our videos therein. Now, I would have our guest do a brief recap, after which we take a short break. But please, let's have Mr. Ireoluwa. I call him barrister. It's not easy to be a barrister many years, 18 or 19 years of your life just to get one certificate. I beg, I'll be barrister, Ojari. All right, Mr. Ireoluwa Oguntunwase, welcome to the program, please.
Yeah, thanks so much, Kayode, and good afternoon, listeners. I think last week we discussed the issue of termination and reduction of wages, and with particular reference to how can employers do, what can employers do in order to ensure safe passage of this so that they can avoid liabilities. So basically we discussed what termination is, and I recall saying that termination is the bringing of an contract of employment to an end. And with respect to that, we actually made reference to Article 4 ILO Convention, and for Article 4 of the ILO Convention, we actually stated that when it comes to termination, that with respect to termination, that there must be a reason for termination. And apart from the fact that there must be a reason for termination, the termination must be done for a reason, and the reason must be premised on good conduct, performance, and operational requirements. And we actually talked about reduction of wages, and for reduction of wages, we stated that when it comes to reduction of wages, it must be done by virtue of an agreement. So that means that an employer cannot just wake up because of COVID-19 and state that he or she wants to reduce wages. There must be a reduction of wages agreement, because wages in line with Section 91 of the Labour Act is just remunerations or earnings designated, is just remunerations or earnings in which is quite stated very clear in the contract of employment. So I think in brief, those are the things that we discussed last week, and I just want to enjoy the listeners to continue with the program, continue with the program and ask the necessary questions so that the program can just move on. Thank you.
Thank you very, very, very much. Like, I told you it was like a 15-minute program. We'll take a very short break now. 15-minute program which he has done, summarized for about 2-3 minutes. If you missed it, and even if you don't miss it, when I got home that day, I think a day after, I saw the video myself. I tried to listen, and I put down some jottings just to enrich my knowledge the more. When we come back, please, I have about 7 questions from last week. I have some for today again, may God help us, but I'll take the ones for last week first. Or Ire will help us about them and address those questions before we take our calls. Let's take a very short break, please. Don't go anywhere. Please call your friends, call your employer, tell them to tune in. Call your employees too, tell them to tune in. Call your landlords, your tenants, your neighbors, that we're about to learn at least one more thing today. Please don't go anywhere. We'll be right back. And you on Rockcity 101.9 FM, speaking live from Abeokuta, Ogun State, Nigeria. I always add West Africa, in case you're listening to us from outside the country. Yes, good enough, we have listeners from outside the country. They call me and say, okay, we enjoyed that program. I say, really? Calling from California, at times Australia and the likes. Alright, we'll go to our questions. My name again, I forgot to tell you, I'm Barrister Kayode Adiremi, and today we have a guest in the house to round off what he began last week. Barrister Ireoluwa Oguntunwase. Like I promised, let's go straight to questions. We hope you have your pen and papers ready to take down the answers to these questions. It's a law program where you are enlightened with what your rights as well as obligations are under the law. Now to the first question. Now, this was sent in by I don't want to mention his surname because he put his mother there, so the mother's employer may be hearing. His name is Temi. Okay. I have remixed his name. Okay. His name is Temi. Temi says, my mother received half salary due to COVID-19. Sorry, what is her legal status? Okay, I don't know whether you got what you're trying to say. My mother received half salary due to COVID-19. Sure. What is the legal status?
Okay, I understand. Now, Temi, I think with respect to the fact that your mother is receiving half salary, we need to understand something. This has to do with wages. Now, like I said last week, Section 91 of the Labour Act, I said wages can be defined as remunerations or earnings, designated or calculated, payable by the employer to the employee by virtue of the contract of employment. Now, that means that wages is not just paid. There must be a contract of employment upon which wages is being paid. Now, that means that at the time when your mom was being employed, I believe the wage clause, which is the consideration, is clearly stated in the contract of employment. And I also believe that there is nothing in the contract of employment to suggest that the wages will be reduced as a result of COVID-19. So the question is this: is it proper or appropriate for your employer, for your mom's employer, to reduce the wage as a result of COVID-19? Now, in answering the question, we need to confirm whether your employer has actually, after the execution of the contract of employment, has actually had a wage reduction agreement with your mom. Now, in the absence of a wage reduction agreement, the employer cannot just wake up and pay into your mom's account as salary half a wage as a result of COVID-19 without a prior agreement. So that is very, very important. Now, if the employer keeps doing this, that means that the employer is actually fulfilling the contract of employment in breach. And where a contract of employment is being fulfilled in breach, then your mom has a recourse to either terminate the contract of employment or go to court and seek for an order of specific performance, so that the balance of the wage or the outstanding wage that has not been paid can actually be recovered from your employer. So I say this: it is not proper or it is not appropriate for an employer to say because of COVID-19 he or she wants to reduce the amount of wage to be paid. Thank you.
Thank you very much, Ibre. I hope Timmy is listening to us, and I want to believe that the parents, the mother too, is listening to us. But let me just, by way of like an addendum to that question, you said if there's an agreement to that effect, having a reduction, what if it's just a notice? An agreement is where two or more parties say that this is what we're going to do.
Yes.
What if the employer just notifies that, madam, this is what you're doing for this COVID-19 period? Would that suffice, please? Or must it be an agreement?
Now, it must be an agreement and it must not be a notice, because the reason it can't be a notice is because notice is unilateral. Now, don't forget that the issue of wage is contractual. It cannot be unilateral. Now, it takes two to tango. And because there is actually an existing contract that stipulates the previous wage to be paid, if that contract is going to be varied, because what this employer did is a variation of the initial contract of employment, and you can't vary an initial contract of employment by notice. You vary an initial contract of employment, which is an agreement, by a supervening agreement. That's why I said they should draft a wage reduction agreement. Now, even in the wage reduction agreement that will be drafted, there will be a clause that is called Incorporation by Reference clause. And the purpose of Incorporation by Reference clause is to show that the previous contract in which contains the previous wage will not be applicable as far as this particular instance, as far as this particular situation is concerned. So it's not something that can be done by notice. It can only be done by a previous agreement.
All right, thank you.
By subsequent agreement.
In other words, since the woman or the employer did not get the job by notice, rather it was by agreement.
Yes.
In the same vein, if anything is going to happen, it should also be by agreement, not
yes.
by.
Yes.
But thank you. Yeah. Now we'll take us to the next question. Where there is no particular agreement, or you've mentioned agreement today, or
Sure.
conditions of service between an employer and employee, what is the procedure for sack or dismissal? Can I just wake up and say I dismiss you? What's the procedure, please?
Now, one thing people need to understand, especially employers need to understand in dismissal, is the implication of dismissal. Now, dismissal is the punitive aspect of termination. Now, when I say dismissal is the punitive aspect of termination, because dismissal carries some implication. And the implication that dismissal carries is that if an employer decides to go ahead and dismiss, the implication is that an employee has committed gross misconduct. Now, what is the meaning of gross misconduct? Now, in the case of merger against tackle, gross misconduct is being defined as any form of conduct that is grave and weighty in character. Now, it is not only grave and weighty, it now affects the relationship of confidence between the employer and employee. Where there is no relationship of confidence, then there is nothing the employer is relying on again. So if the employer is saying that I want to dismiss, and there is no procedure for dismissal in the contract of employment, it is very, very important that the employer follows the principle of natural justice. Now, what is the principle of natural justice? The employer must ensure that he or she gives the employee the right to be heard before going ahead to dismiss. Because dismissal is usually as a result of gross misconduct, as a result of an allegation which is very, very weighty in character. So natural justice, in short, We usually narrow it down to what is called the principle of audio autarem patem. That is, hear the other side. That is what it means. It's a Latin maxim. Audio autarem patem, hear the other side, and nemo judex in causa sua. You can't be a judge in your own case. Now, the application of this principle is that in the event of dismissal, the employer must ensure that the employee is given opportunity to be heard. This opportunity can either be oral or in writing. If it is oral, it can either be in form of calling a disciplinary panel so that the employee can also present his own defense, or it can also be in form of giving a query and the employee will respond to the query. Yes.
Let me just quickly come in at this point. So if these procedures are not followed,
yes,
what options are available to an employee that has been dismissed without following this procedure?
Very well. Now, if this procedure is not followed and the employee is being dismissed, then that means the employee can actually challenge the dismissal. It is actually called wrongful dismissal, although depending on the class of employment. Now, we have what is called common law employment and we have what is called statutory employment. Now, if it is a common law employment, it is called wrongful dismissal. If it is a statutory employment, it is called unlawful dismissal. But most people don't know that there is a difference between wrongful dismissal and unlawful dismissal. Wrongful dismissal is dismissal without following the procedure in the contract of employment. Unlawful dismissal is dismissal without following the procedure as stated by the law, because the employer is a creation of law. For example, assuming we have an employee that is working in a particular ministry. A ministry is usually seen as a creation of law. Assuming we have an employee that is working in a particular government agency and such an employee is being dismissed without following the procedure of, let's say, civil service rule or public service rule, that is an unlawful dismissal. But assuming we have an employee, in which the employment relationship is governed by contract of employment, and the contract of employment actually states how the dismissal will be done, and that is not followed, that is called wrongful dismissal. So wrongful dismissal is a form of dismissal in breach of contract of employment. Unlawful dismissal is a form of dismissal in breach of the law that creates or regulates the employer.
Well, thank you so much. If you're checking our time now, see that time is just flying every Sunday, 3 to 4 p.m. Let's see how far we can go today before we begin to take your calls. I will try and do a summary in Yoruba. Fún àwọn tí a kò gbọ́ èdè Gẹ̀ẹ́sì, fún ọkọ̀ tí wọ́n ti ń sọ látẹ̀kọ́, a máa gbìyànjú láti bá wa túmọ̀ ẹ̀ sí èdè abínibí wa. I will try as much, but let's take some other questions in Ireoluwa. For time's sake, let's do some speed. This one says, is pension, I'm sorry I'm not calling out our names, I just wrote down our questions for those asking us these questions. Is pension scheme compulsory for private workers? Can their employers insist that they must participate in pension scheme? In other words, is pension scheme compulsory for private workers?
Yes, pension scheme is compulsory for private workers. The position is very clear in the Pension Reform Act 2014. I think section 2 therein makes pension scheme compulsory for private workers. And if we also look at section 4 of the Pension Reform Act, it now gives the percentage that will be contributed. So without prejudice to whether you are a private worker or you're a public worker. Now, pension is a form of statutory welfare scheme that has been provided by the government, so that in the event of retirement or in the event that you have been unemployed for a particular period of time, at least you have something to fall back on. So to this extent, an employer cannot wake up and say, I'm not paying pension. It is a breach of that particular statute, and there are penalties for it in the Pension Reform Act. I think if this is being done, the affected employee can actually write to the National Pension Commission, and this will be appropriately handled.
Well, thank you very much, Ireoluwa. And now to the next question. Again, like I said, I will try and say in very brief words what these things mean in Yoruba language. Is it compulsory for employees to give notice of job quit? Or can I just quit without telling my employer? Or is it compulsory? Can I just... Can I just quit, or must I notify my employer before I quit?
Now, thanks so much, Kyle. I think let me quickly correct this. Now, when we say notice to quit, it is now actually notice to quit. It is notice to terminate. So with respect to employment contracts, it is usually necessary for either of the parties to give notice, and this is the reason. Now, where notice is given, notice is usually anonymous, an intention that I don't want to work again. In law, we call it anonymous. So if you give notice, you're trying to give an intention. You're trying to tell the other party that come this particular time, I'm not coming again. It is not appropriate. And in terms of international best practice, it is not even the best international best practice for the employee or employer to just terminate without giving notice. Although, while I will agree that most times notice is usually contractual, and when I say contractual, the duration or the quantum of notice is usually being stated in the contract of employment. But there are instances whereby, maybe for error of omission, or for the lapse on the part of the drafter of the contract of employment, the appropriate period of notice will not be given. Now, in this particular instance, the law is also very clear, and the law says that in determining the notice that will be given, where the quantum of notice is not stated in the contract of employment, then the law says that you give reasonable notice. Now, what is reasonable will now depend on the fact and circumstances of the case, depending on the position the person occupies in the organization, and also depending on the organizational policy or the custom of the organization. So, in answering this question, I would say yes, notice is important to be given, either by the employer or by the employee, so that either parties can prepare for eventuality.
All right, thank you. That will be a yes for short. To the next question, quickly, number 5 question. I have not been paid my April and May salaries. My employer claims COVID-19 is the reason and that he will not pay. I think this has been addressed by the second or first question.
Yes.
There ought to be an agreement to that effect if that will happen. I think
Yes.
we can leave that and
Yes,
move on.
yes, and I think I need to also add something to this. Now, there is Section 5 of the Labour Act, and what the Section 5 says that you cannot just go ahead. Section 5 gives a legitimate instance whereby wages can be reduced, and it says that if in the event of pension and in the event of tax, so the employer cannot just wake up and say that I'm not going to pay wages because of COVID-19. Why would the employer do that? Now, payment of wages is an obligation on the part of the employer. As far as the contract of employment is still subsisting, the employer has an onerous obligation to pay wages.
What is onerous? Lawyer?
Now, onerous
For the
means
sake of our listeners.
onerous means a mandatory obligation to pay wages. Wages is not only payable. The employer can only say that I'm not paying wages when the contract of employment has come to an end. So as far as the contract of employment is existing without prejudice to whether we have COVID-19 or we don't have COVID-19, then the employer is under a duty to pay wages. If the employer has failed to pay wages, then the employee has a right to actually institute an action against the employer at the appropriate quarters to claim for the wages.
All right, thank you. I think I should, at this point, quickly summarize what we have so far for time's sake. The first question by Timmy: my mother receives half salary. The answer, wọ́n ní ẹnìkan wọ́n fi ìbéèrè ránṣẹ́, ó ní ìyá òun wípé owó oṣù àbọ̀ ni wọ́n fún wọn nítorí kòrónà tí ó gba òde kan yìí. Àlejò wa sọ wípé kò lẹ́tọ̀ọ́ bẹ́ẹ̀, wípé ó yẹ kí wọ́n ní àjọsọ láàrin tó gbà wọ́n síṣẹ́ àti ìyá Tèmi, wípé orúkọ báyìí kò yẹ kó rí bẹ́ẹ̀, ó yẹ kájọsọ kí ó jọ wà láàrin wọn, tá à ń pè ní agreement. Ìkejì, is pension scheme compulsory? Ṣé dandan ni kéèyàn ṣe pension fún àwọn tí òṣìṣẹ́ ìjọba? Wọ́n ní bẹ́ẹ̀ ni.
True freedom requires the rule of law and justice. But what is justice without respect for human rights? What are these rights? Do you know your right as a citizen of the Federal Republic of Nigeria? What are your obligations and responsibilities under the law? Join Kayode Aderemi Esquire on The Law and You on Rockcity 101.9 FM, Sundays 3 p.m. to 4 p.m.
Ìpín nǹkan tí òfin sọ nìyẹn, èèyàn gbọ́dọ̀ ṣe pension. Ìkẹta, where there is no particular agreement or conditions of service between an employer and employee, what is the procedure for sack? Ìyẹn túmọ̀ sí pé tí ò bá àwọn kan àti ẹ̀kọ́ máa ń gbé àwọn síṣẹ́, kò ní sí nǹkan tá à ń pè ní àjọmọ̀ láàrin àwọn méjèèjì. Iye báyìí bàbá ìlú máa bẹ̀rẹ̀ iṣẹ́, bàbá ìlú máa close, iye báyìí ló máa gbà, báyìí tó wá fẹ́ sack ẹ̀ bá ṣe máa ṣe ilé. Tí ò bá sí irú nǹkan bẹ́ẹ̀ yẹn, báwo ni wọ́n ṣe lè ṣe láti yọ ní níṣẹ́? Wọ́n ní gidi kan wá náà pè ní odi ọ̀tẹ̀rán patem, àmọ́ tí bá wa sọ̀rọ̀ nípa ẹ̀ bí ọ̀sẹ̀ bíi 4-5 sẹ́yìn fún àwọn àtàbá ń tẹ̀lé ètò ìyàpẹ̀ tàbá rántí. Wọ́n ní ó ṣe pàtàkì kí ẹni tí a fẹ̀sùn kàn kó wá sọ pé báyìí ló ṣe rí àbí báyìí kọ́ ló ṣe rí. Ṣùgbọ́n táwọn kan bá dá jókòó tí wọ́n ní ìwọ ló ṣẹ̀, wọ́n dẹ̀ gbaṣẹ́ lọ́wọ́ ẹ̀, wọ́n dẹ̀ gbọ́ tẹnu ẹ̀, ó lòdì sí òfin ilẹ̀ wa tí à ń pè ní fair hearing, both parties must be heard. Ètò tẹ̀lé, is it compulsory for employees to give notice of job termination or job quit gan lọ pé ẹni tó fi béèrè yẹn ránṣẹ́? Ṣé dandan ni kí òṣìṣẹ́ kó sọ fún ọ̀gá ilé iṣẹ́ ẹni tó níṣẹ́ pé òun òṣìṣẹ́ mọ́, ìyẹn tó wá fẹ́ dáṣẹ́ dúró? Wọ́n ní bẹ́ẹ̀ ni ó ṣe dandan, ó ṣe pàtàkì. ó dẹ̀ ó tún ní í ṣe pẹ̀lú iṣẹ́ tó bá gbà ń bẹ̀ tọ́jà kí wọ́n ní manager ní tọkọ̀ dédé jí tó wà mọ́ wà lẹ́ pé iṣẹ́ yẹn ó ṣeé ṣe kí kó má lè lọ síwájú mọ́ nítorí ẹ̀ ṣùgbọ́n tọ́jà pé ẹ pọ̀ lẹ́nu ẹ̀ bóyá ẹ̀ ń ta epo gẹ́gẹ́ bí àpẹẹrẹ àwọn bíi ogún 20 ni wọ́n ń ta epo tí wọ́n nìkan ò bá wá ẹ̀ pé iṣẹ́ á sì lọ ṣùgbọ́n tí manager ò bá wá ó máa ṣòro kí iṣẹ́ lọ wọ́n sọ pé ó tún láti ṣe pẹ̀lú nǹkan tí ò ń ṣe ìbéèrè tó kẹ́yìn wá wo pé ìyẹn wọ́n ti dáhùn ẹ̀ bákan mímẹ́ tó fi ìbéèrè yẹn ránṣẹ́ ẹ má bínú kí mi ò ka orúkọ yín síta mo kọ̀ kọ àwọn ìbéèrè wá síta ni ó lóun wọn ti fún un ní owó oṣù April àti May wọ́n ní kò yẹ bẹ́ẹ̀ ó yẹ káwọn gbèsè kan wà tẹ́ kí wọ́n gbé kó tó di pé wọ́n ṣe bẹ́ẹ̀ tí wọ́n bá ní san owó ẹ̀ àti sọ yẹn sí ẹ̀yìn. Thank you very much. Let's continue quickly for time's sake. How do we handle private hospitals who train and employ quacks? How do we handle private hospitals who train and employ quacks, Mr. Ireoluwa?
Now, there is something we need to know, and the fact that there are always regulatory agencies for every sector, and the health sector is not devoid of regulatory agency. So I think if, as a patient in an hospital, you have reasons to believe that the hospital has employed quacks, you can write a petition against the hospital to the relevant regulatory agencies. And relevant regulatory agencies include the Medical and Dental Practitioner Disciplinary Committee, or it can even include the Commissioner for Health, the Office of the Commissioner for Health. I believe that every state has the Office of the Commissioner for Health, so that can be done. But in addition to that, I think the hospital is also opening to themselves to liability if they decide to employ quacks, because the common law principle of negligence is very clear. You know, the hospital can be vicariously responsible for any action that the supposed quacks has done on their behalf, and that will open them to barrage of liabilities to which they may not be able to get out from. So that's very important.
Thank you very much. You can write to the Commissioner for Health as well, or
Yes.
the Disciplinary Committee.
Yes.
I worked in a hospital. While I was there, a certain percentage was deducted from my salary. After 6 months, I resigned. I then approached my employer for payment of my pension, as I was no longer working there or interested in working there. To my shock, I was refused. The pension company refused me and told me that I had to have clocked 50 years and can only apply for 25% after my employer has written to them that I have quit. Is this right? Did you get the question, please?
Yes, I got the question. Actually, when it comes to the pension scheme, there are instances in which you can now start claiming pension. And like I said, the provision of the Pension Reform Act is very clear. Now, the question you need to ask yourself, with due respect, is that what is the period in which you are out of work? If you are working in a particular place and pension is being regularly deducted, and maybe you now left that place a month, you are still not entitled to pension if you've not clocked 50. Now, the position is very clear. Is either you are 50 years old or you've been out of work for like 3 months, upon which you now be able to claim 25% of the total amount of pension. So I think the position is very clear.
So the pension company was right to have told her that she needed to be 50 years old.
Yes,
or,
yes.
Be entitled to 25%.
Yes,
only if she's out of work for 3 months.
For 3 months. They
So
just
who will
restated the
now
law.
tell who that I've been out of work for 3 months? Is it that would be his or her job to tell the pension company that I've been out of job for 3 months?
Now, it's very clear. When you tender your resignation letter, that's why it's good to resign properly. If you tender your resignation letter, the resignation letter will carry the date that you resign. Now, between the date that you resign and the date that you apply for your pension to be paid, that's the timeline within which they will now use to calculate whether you're entitled to 25% or not.
All right, thank you. Well, let's take this one last one that we'll translate in Yoruba and open the call lines. The other one says a 19-year-old man lost his 5 fingers at workplace by the company machine. The company did not pay him hazard allowance. Is this legal? Somebody was working in a company and he lost 5 fingers in his workplace by the company machine, and the company did not pay him hazard allowance. Is this right?
Now, before we can even start talking about hazard allowance, I think employees really need to understand their rights. Now, there is what is called the Employee Compensations Act that regulates all this. Now, the Employee Compensations Act is a form of insurance for the employer. You know, in the instance that maybe while you employ someone, the person is working and gets injured in the workplace, you know, the employer, if the employer has been following strictly, has complied strictly with the provision of the Employee Compensations Act, of course it will be easier for the employee to approach the NSITF, which is the Nigerian Social Insurance Trust Fund, for payment. And in this instance, something can be given to the employee. It will be strictly calculated and it can be given. But even above this, it still doesn't exculpate the employer from potential liability of negligence if the injury, the loss of 5 fingers that happened to the employee at the workplace is as a result of the act or omission of the employer to do what they should have done. So I think that in this instance, the employee has 2 recourse. The employee can either approach the Nigerian Social Insurance Trust Fund to confirm whether the employer has actually been remitting the appropriate amount of money so that he can claim from them, or if the employee feels that the injury that occurred is as a result of the negligence of the employer, then the employee can actually sue the employer for negligence.
I hope the person that asked this question is actually listening to the response. A part of me feels that the person will need more enlightenment, more questions to ask. If that's the case, if Mr. Ireoluwa will not mind, after the program, I will read out his number so you can contact him to ask his question. Now let's open the call lines so that we can take your questions. We won't be able to take more today, as you can see. Time is fast spent already. This is time is so gone already. Again, after our guest has responded, I think I'll have an advice, a general advice for all our listeners on this payment thing / COVID-19. Before he responds, he talked about the question that someone asked: how do we handle private hospitals who train and employ quacks? Wọ́n ní àwọn tí àwọn ilé-iṣẹ́ ìwòsàn tí wọ́n máa ń gba àwọn tí ò kọ́ṣẹ́ síṣẹ́, wọ́n wá kọ́ wọn láìka aṣọ bíi green àbí blue máa ń wọ̀ báyìí, wọ́n ní kílẹ̀ ẹ̀kọ́ ṣe sí. Wọ́n sọ pé irú dókítà bẹ́ẹ̀ yẹn, àbúrò nọ́ọ̀sì bẹ́ẹ̀ yẹn, wípé ó ń fi iṣẹ́ ara ìwé ewu nìyẹn. Negligence ó lè fà á, wọ́n lè torí ẹ̀kan gbé ni lọ sílé ẹjọ́ àbí kán kọ lẹ́tà ìwọ tó wọ́n mọ̀ pé dókítà kan ṣòro nǹkan bẹ́ẹ̀ yẹn, ó lè fi ìwé ṣọwọ́ tàbí ní petition sí disciplinary committee àwọn health workers àbí sí commissioner, nítorí wípé ẹ mọ̀ pé ẹ má jẹ́ ká wò ó pé bí a fẹ́ bà tẹni yẹn jẹ́ ni, no, because ẹni yẹn ló fẹ́ bà tẹyàn jẹ́. Ẹni tí ò mọṣẹ́ tó ń fún yàn lábẹ́rẹ́ tó bá lọ gún yàn lẹ́sẹ̀ lẹ́sẹ̀ lè wọ̀ ó lè pààyàn gan, ó lè gbẹ̀mí èèyàn síbẹ̀. Ìbéèrè tó ń béèrè, I work in a hospital and torí àkókò wọ́n ní àwa tí wọ́n bá ń yọ pension tí a ò kí ń ṣe òṣìṣẹ́ ìjọba a ní láti pé ọmọ ọdún 50 years old náà. Ṣé àádọ́ta nìyẹn, or there about 50 years old, àbí kó ti fi ṣẹlẹ̀ fún oṣù mẹ́ta ó kéré jù kó tó lè gba 25% nínú owó tí wọ́n ń bẹ dá síbẹ̀. Wọ́n ní nǹkan tí òfin tí ó sọ nìyẹn. Ọkùnrin tó lóun ṣiṣẹ́ níbi iṣẹ́ tó ní machine gé ìka àwọn márùn-ún, wọn oríṣiríṣi dáhùn tí wọ́n fi sí máa gbà ẹ́ lámọ̀ràn tó jẹ́ Yorùbá ní ẹ́ láti pè wọ́n lẹ́yìn ètò yìí, and if it's English, call him as well. I'll try and call out his number for you to ask him questions, and any other person that want to ask him any other thing as well regarding what we are discussing. He will explain better to you. There are some people you can write to, and there's some steps you can take as well if you think that your employer Alright, let's quickly get very brief response to our questions. Time is fast spent already. Questions that are called, starting from Mr. Umoru. He was paid 50k, was slashed to half. What can he do?
Yes, for Mr. Umoru, pay 50k and your salary is just suddenly slashed to 25,000. Now, like I said before, this is reduction of wages, and the question still remains that is there an agreement to that effect? If there is no agreement to that effect, that means that the employment is now being operated in breach. Like I said, the fact that there is COVID-19 doesn't give the employer the right to just go ahead and reduce. There is a procedure, in which this can be done, and failure to follow the procedure actually opens the employer to liability. So, if I may answer your question, of course, you are entitled to justice. Of course, you are entitled to remedy, because the amount that you've been consistently being paid, is 50,000, and that amount has now been reduced. So in getting justice, you can file an action at the National Industrial Court, which is the court specifically created to handle employer-employee matters. So that is that. And again, if there is any agency, dispute resolution agency, you can approach the dispute resolution agency and write to them so that they can also call the employer. Both of you can have a meeting, and they can understand the reason the employer is actually doing that. But in the event you don't have money to engage a lawyer, you actually have that you actually have that right to approach any organization that does pro bono services, legal pro bono services, so that they can take up the matter for you. Now, Mr. Tunji, for employee that just suddenly left the place of employment, there is something that is called AWO, absent without leave. And notwithstanding whether the contract of employment actually states whether AWO is a gross misconduct or not, AWO is impliedly a gross misconduct. That is making yourselves absent at work without leave. So that means that if you are in a contract of employment as an employee and your job stopped coming and you didn't even notify your employer, that is a ground for dismissal, or that is a ground for the termination of the contract of employment. Now, for Mr. Vincent, you've been working for 15 years and no pension contribution is being paid. You can approach the National Pension Commission. You can write to them, and in writing to them, you need to attach your contract of employment and your pay slip. There are some documents that they are going to request from you to show that you've actually been working for 15 years without payment of pension. And I will also advise, part of the things they can also tell you is that maybe you should terminate your contract of employment with them so that it can now be so clear. You understand? But it is not proper for an employer not to pay pension. It is not proper. There is no reason whatsoever, that an employer can give for not paying pension. No reason whatsoever, whether a private employer or a public employer. Pension is a statutory welfare scheme that must be paid. And even in the Pension Reform Act, there are penalties for non-payment of it, and there are penalties for failure to pay within the stipulated period of time. So, Mr. Vincent, you have a recourse. Just write to the National Pension Commission and they will take it up from there. Now, for Mr. Olalekon, private schools, they are not paying because the children is not coming to school. Actually, it's a very difficult period now. It's a very difficult period. But again, the school also needs to understand something, that in order not to open themselves to liability, there are some legal steps that they really need to pay, that they really need to take. Now, one thing that we normally do is that we leave everything to chance, and we leave everything for people to understand. We'll be saying that, the teachers should understand. But again, when the matter gets to the appropriate quarters, will the court understand? So I think the school should go ahead and draw up an agreement with the teachers, saying that for this particular period, salaries will not be paid. Without that agreement in place, I think the teachers have a recourse against the school, without prejudice to whether there is COVID-19 or not, without prejudice to whether the students are coming to school or not. Of course, I know that when it comes to establishment of schools, it is from the students that the school management will get money to pay the teachers. But again, the fact that the teachers have already been collecting salary, it has created a contractual relationship between the teachers and the school. So if that is going to change, there must be an agreement stating that that has actually changed. Without that, it cannot be left to chance and it cannot be left to implication. Thank you.
Wow, what a deep one actually. I said I was going to say something after he has responded. He has given us very, very deep insight at exactly as to what the law is about these questions. It's a program about your rights, your law, your obligations and rights as Nigerians, or even non-Nigerians actually. All right, these laws cover everyone within Nigeria. But while we do this, we should remember, that I think I should mention that because at times I go to Alake Palace, at times I have some ballets too that I discuss with, and they try to settle conflicts and the likes. We should juggle many things together. I think that's the beauty of Yoruba land generally. I did a lot of study about Yoruba etymology, about words and Yoruba, ADR, like sure. Lawyers were taught, ADR actually had its roots in Yoruba traditional system.
Sure.
If I did something, maybe my mother is listening to me now. If my elder brother did something I didn't, I wasn't happy. Mother would call me and she would spank me and say, I will feel bad.
Exactly.
While I'm feeling bad, she will come over to and spank him and say that boy
Exactly.
So we don't do the adjudicatorial system that we do now in the legal system where somebody is totally wrong, the other is totally right. They try to strike a balance. So we should bear that in mind too. And the Oyinbos are coming back to our style really to bring what we call a mediation, negotiation, and the likes. We should have that in mind too. Put human face so that we have less conflicts around us as a people and as a country. It's been a beautiful time here, and for those asking to speak with Mr. Ireoluwa after now, to asking further questions and other issues, of course, like I said, you are either an employer or an employee. So, and this is a master, I can tell us for free when it comes to that. His numbers, if you wish to speak with him, like I can see a question asking me for his contact. Feel free to call him, please. 070-6372-5524. I take that again, please. 0706-372-5524. His other number, alternative number, is 0705-629-2571. 0705-629-2571. His name is Mr. Ireoluwa Oguntunwase. As I sign out for today's program, I want to thank everyone, all of our listeners. Thank you also to Mr. Ireoluwa, who had to travel down several miles for today's program. Thank you so much for coming around. And then to his friend, what's her name? Let's those at home here.
Yeah, Adewale Adesoya.
You can hear that voice, very chilled brother. Adewale Adesoya. Thank you very much for coming around. Please, I always tell us that I'm sure when I leave the studio now, calls will start coming in, people will start reporting issues of raid, battery, police assault and the likes, soldier assault, the people beating them up. What I've discovered is this: oppressors hate it when you ask questions. Oppressors hate it when you ask questions. Imagine if a police officer barges into you now and says, give me your phone, and start scrolling through, and you are quiet, you don't say anything. Of course you have a field day. When you say, excuse me sir, why do you want my phone? They begin to get agitated. So I've discovered that please let us keep asking questions. Let us keep asking questions. It is at least the first step to liberation. We all want freedom. We want liberation, and we must ask questions if these things must be. Nigeria will be free again, I believe, in this my own time. We shall do all we can within our own power or presence, alright, to ensure that peace and freedom reigns supreme in this land. The rule of law shall reign again. Please, let's always ask questions. In case you want to, do advert and marketing, feel free to call our marketing line 0814-998-8672 or 0808-2500-745. That's Modino Tadenekon's number. Please feel free to call her and buy more time for this program. Do some adverts. Feel free, please. It's important. Please, whatever thing you do between now and next week Sunday, ensure, like I always say, that you are on the right side of the law. My name again is Barrister Kayode Aderemi. God bless you.